Hi, I'm Ken Lammers, and welcome to this week's LexCast. Before we start, I want to wish a happy birthday to Brad. Brad's one of my fraternity brothers from Delta chapter of Phi Kappa Tau at Center College. Brad was the smart one, the guy who had the TV on, and while he was watching the TV was surfing the internet, and while he was surfing the internet was doing his advanced physics homework. Kind of left me in the dust. Anyway, well, it's pretty obvious since I do law and he's now a doctor, earning, I'm sure, gazillions of dollars in the northern Kentucky, Cincinnati area, that, well, I mean, as we all know, the difference between lawyers and doctors is they can do math. Well, anyway, Brad, I really wish I could be in Kentucky this weekend. I can't. Things are going on here in Virginia I got to take care of. And I just want to wish you a happy birthday and many happy returns. And now, ladies and gentlemen, let's move on to the meat of today's issue. We're going to talk about interpreting statutes, the proper manner in which one should interpret a statute, and we're particularly going to talk about Virginia Code Section 18.2-308.2, which is the felon in possession of a firearm statute. We're going to talk about the punishment section of that statute and how the plain language reads, and how using the interpretive canons it can be interpreted. And then we're going to compare it to a case called Carter against the Commonwealth. And ladies and gentlemen, with that, I'm going to move forward. What you're seeing here is the entire statute as it now exists, or at least Section A of the entire statute as it now exists, which is the primary part of the statute, which lays out what the crime actually is, what a single exception to the crime is, and what punishments exist for the crime. This is as it exists right now. And what you're seeing here is the statute with the sections in yellow are brand new. They were put in place on July 1 of this year. And the red section is a point where they changed found guilty to adjudicated delinquent. This is a statute. These parts of the statute aren't really important to the argument I'm going to make because they were put in, well, after the case I'm actually arguing. And so here's what the statute looked like in the case that I'm arguing, which was from before July 1, and in the case Carter against Commonwealth, which was applied to the statute. If we break the statute down into sections, which it would have been nice if the legislature did, a little bit more breaking down, but if we break it down, we can see here the green section is what the actual violation of the law is. The blue section is an exemption or exception to the law, and the red section is the penalty portion of the law. Now here's a closer look at what it takes to violate the law. It shall be unlawful for 1. Any person who has been convicted of a felony, or 2. Any person under the age of 29 who is found guilty as a juvenile 14 years of age or older at the time of the offense of a delinquent act which would be a felony if committed by an adult, other than those felonies set forth in Clause 2, whether such conviction or adjudication occurred under the laws of the Commonwealth or any other state, the District of Columbia, the United States, or any territory thereof, to knowingly and intentionally possess or transport any firearm or stun weapon, taser, as defined by Section 18.2-308.1, or any explosive material, or knowingly and intentionally carry about his person, hidden from the common observation, any weapon described in subsection A of Section 18.2-308. Okay, somebody's got to get a hold of our assembly members, General Assembly members, and teach them what a run-on sentence is and why it's a bad thing. Anyway, here's the second section, which is something we're not going to be talking about all that much, but I thought I'd read it so you know what it is. However, such person may possess in his residence or the curtilage thereof a stun weapon or taser as defined by Section 18.2-308.1. And then we get to the punishment section. Any person who violates this section shall be guilty of a Class 6 felony. However, any person who violates this section by knowingly and intentionally possessing or transporting any firearm and who was previously convicted of a violent felony as defined in Section 17.1-805 shall be sentenced to a mandatory minimum term of imprisonment of 5 years. Any person who violates this section by knowingly and intentionally possessing or transporting any firearm and who was previously convicted of any other felony shall be sentenced to a mandatory minimum term of imprisonment of 2 years. The mandatory minimum terms of imprisonment prescribed for violations of this section shall be served consecutively with any other sentences. Before we go any further, let's discuss a few terms. To begin with, a Class 6 felony is a felony which carries from 0 to 5 years. From no time to 5 years. It is the lowest level felony in Virginia. Another important thing to understand is that when we say adjudicated a juvenile delinquent, we mean that it's a civil juvenile finding. That is a civil case, not a criminal case. And finally, although I doubt anybody really needs to be told this, a conviction is something that occurs in a criminal case. First of all, let's look at this through basic English. The stuff you learned in the 7th grade English course. We've got here are two phrases connected by a conjunctive, not a subjunctive. So you look at the first phrase, however, any person who violates this section by knowingly and intentionally possessing or transporting a firearm, any firearm. Okay, so you violate by being a person. If a person violates this section, okay, so we get that part. The conjunctive is obviously and then who was previously convicted of a violent felony. Okay, the second phrase is a dependent phrase. It's dependent on the first for the subject, so we look back to the subject, the first one, it is person. It can't be any person because that would make a nonsensical sentence. You would have any person who violates this section and any person who was previously convicted of a violent felony would get, a minimum of 5 years in prison. So merely having been previously convicted of the violent felony would in that case get you the 5 years in prison. So what we have here is one phrase which sets out a class, any person who violates this section. And you have a second phrase which is a restrictive phrase, who was previously convicted of a violent felony, which sets out a subclass of the original class. And that specific subclass is to get the mandatory minimum of 5 years. Well, who's in the specific subclass? It is a person who has violated this section and who is previously convicted. Okay, there's no language there at all about adjudication. And then if we move on to the canons of statutory construction, one of the basic canons of statutory construction is expressio unius est exclusio alterius, which, if you'll excuse my terribly pronounced Latin, basically means if you say one thing, you exclude another. Well, if we look to the second phrase, the restrictive phrase, it says previously convicted of a violent felony. That restrictive phrase expresses one thing. Therefore, it excludes the other thing. It excludes the adjudication for an act which would have been considered a felony if he'd been an adult. So that's not included in this section. It's not included in this punishment. Now we know from various cases, and I'll just cite you one, Coca-Cola Bottling Company of Roanoke, Incorporated against the County of Botetourt. That's from 2000. And there's also a Court of Appeals case, Farnsworth against Commonwealth, which applies this in criminal law. We know that judges are not allowed to amend or change the meaning of a statute. They're not supposed to do that. And I actually picked up from, I think this was from Crime and Federalism. There was a opinion about how the absurd reading doctrine is restricted to constitutional law and scrivener errors. That it's not meant to be used in the interpretation of statutes because, well, if you are finding that something is an absurd reading because of the substance of the matter, then you are determining that your belief of what the substance of the matter should be is superior to the legislature's belief as to what the substance of the matter should be. You're choosing what the right substance is, and you're changing the statute. And that's not a correct way to interpret statutes. Finally, if there was any ambiguity here, and I don't see any ambiguity, but if you should think that there is any ambiguity here, the rule that would apply is, well, let's see, what's the exact quote? We have said too often to require citation that criminal statutes are to be strictly construed in favor of the defendant and cannot be extended by construction or implication to favor the Commonwealth. So, statutes are to be construed in favor of the defendant. Yeah, I know it's not a rule that Virginia courts of appeal really apply, but it's out there theoretically. Now, in Carter against the Commonwealth, someone raised exactly the arguments I'm raising. Well, maybe not exactly the arguments I'm raising. They apparently seemed to claim that there was ambiguity here and it had to be construed in favor of the defendant. Well, the appellate court in Carter, well, it puts a whole bunch of the boilerplate in about how they're supposed to enforce legislative intent, use the plain language, ordinary meanings. They can consult other statutes to get the meaning, and basically they say the intent of the legislature trumps the words of the statutes. Well, that's not a fair. That's not a fair interpretation of what they say. Here's the actual language. Although penal laws are to be construed strictly against the Commonwealth, they ought not to be construed so strictly as to defeat the obvious intent of the legislature. Which is a way of saying we're going to ignore the rule of lenity, even if it is one of the most ancient rules of interpretation. And having gone through all the boilerplate language, the Court of Appeals in Carter then goes on and starts talking about how in this statute, in several places in this statute, including two in the section you have right in front of you right now, it uses any person. I think it uses like 4 or 5 times in the statute. Up at the top, it talks about any person who violates the statute by having been a felon who has a firearm, or any person who violates it by having been a delinquent under the age of 29 who has a firearm. The language that it says here in the opinion is, contrary to defendant's argument, the statutory language promotes inclusion, not exclusion. It relies heavily on this any person argument and says that, well, juvenile adjudications of delinquency are to be included, and therefore we find the defendant is, we don't overturn the defendant's conviction. Obviously, this case drives me nuts. Now, the trial judge didn't have any choice but to follow it because it is precedent. It's a published opinion in Virginia. But there's nothing ambiguous about this statute. I mean, it clearly sets out which subset should get the 2 years, and it does not state those adjudicated a juvenile delinquent. And the legislature clearly knows how to do this, because in the first part of the statute where it says who can be found in violation of this statute, it talks about those convicted, and it talks about those adjudicated juvenile delinquents. And in the more modern version of the statute, the newer version of the statute this year, it even goes further and sets out two different groups of people who are adjudicated juvenile delinquents. And in the more modern version of the statute, it even goes on and, well, the legislature obviously finds that it removes found guilty from of an offense which would be adjudicated or would otherwise be a felony, and makes it is adjudicated a delinquent. So it recognizes the difference between adjudication and conviction at the first part of the statute, and then later in the statute it changes, it actually restricts even further who can be subject to the 2-year part of the statute by saying you have to be convicted of a felony within the last 10 years. So the legislature is not looking for an expansive reading of this section, which is pretty obvious from what they've done. They're looking for an expansive reading of who can violate it, but they're not looking for an expansive reading of who is going to be punished. Or at least that's an extremely viable reading. Quite often in Virginia, and I'm sure you see this in other states too, we get these words of how wonderful we are going to be following legislative intent, but we never really get where the legislative intent comes from. It seems to kind of appear out of whole cloth. But, you know, that's sour grapes from a defense attorney. Take it with that grain of salt. Then in 2005 came a case called Conkling against the Commonwealth. And in Conkling, there was a case where the prosecutor and the judge had used a prior juvenile adjudication as a prerequisite conviction for the felony petty larceny statute. In other words, on your third or subsequent larceny, it's a felony whether or not you stole over $200 for the stuff. So they had used a juvenile adjudication. The Court of Appeals looked at it and said, no, there's nothing in the statute that says you can use adjudications. It just says you can use convictions. Well, the Commonwealth, with some justification, goes, but wait a second. Back here in Carter, it didn't work that way. We didn't have to come up with this, extra language about juvenile adjudications. It shouldn't work that way here. And the court in Conkling just has an absolutely painful analysis where it tries to exclude Carter to its own evidence, to its own facts. And the way it gets there is, you see here, here's a parsing of the statute. It parses the statute, and as you read through, here's the way the statute would read from Carter as interpreted in Conkling. It shall be unlawful for 1, any person who has been convicted of a felony, or 2, any person under the age of 29 who is found guilty as a juvenile 14 years of age or older to knowingly and intentionally possess any firearm, and it goes on, any person who violates this section shall not be eligible for probation and shall be sentenced to a minimum mandatory term of imprisonment for 5 years. Okay, now, if you look at where I have there, you'll notice that there's a section missing. And what's the section it's missing? The section it's missing is the restrictive phrase which sets the actual subset of person who's supposed to be subject to this 5-year penalty. Why? Because unless you skip that restrictive phrase, it doesn't make any sense to interpret the statute the way Carter does. The plain language of the statute is contrary to the statutory interpretation in Carter. So they basically have to ignore a section of the statute. That, ladies and gentlemen, is amending the statute. You don't just amend when you add something. You amend when you take something away. And in order for prior precedent to stand, they had to amend the statute. Carter's not incredibly clear on all this, but Conkling is. I mean, the statute's amended. They take out a section in order to make it work. Seems to be problematic for me, but as of now, it is the presiding precedent. Hopefully, maybe even through the case I'm filing, that this will get changed, but for right now, that's what we got. Well, let me conclude, ladies and gentlemen. The statute, in my opinion, has a plain meaning. There's not any ambiguity here. There's nothing really all that tough to interpret. Carter's a rough opinion. It's just, it's a rough opinion. And it leaves us with a tough spot where you have a statute that says one thing, but the case law actually says something else. And, well, it hasn't reached the Supreme Court of Virginia yet. Hopefully they'll get it, or maybe whoever next challenges the statute and actually gets it heard will get some sort of en banc hearing or something, and it'll get all straightened away. Anyway, that's something for the future, and we'll see how it all turns out. Ladies and gentlemen, that's it for today. I hope this made some sense. I hope it illuminated some things, and God willing, nobody in the Court of Appeals is going to be upset about this. Of course, figure the odds that anybody from the Court of Appeals is watching this. Anyway, ladies and gentlemen, with that, I'm going to wrap it up today with the normal caveats. This is not authoritative. Do your own research. Don't cite me to a judge. For goodness sake, do not cite me as authority to a judge. Go look it up yourself and make the arguments, because you probably will make them better. And with that, ladies and gentlemen, I wish you a good week. Next week, we'll see. Maybe even I'll make an appearance on the camera next week. We'll have to see about that. Have a good week.